Nagraj Shetty, are you
Yes,
there?
madam. Yeah, I'm there.
Already 9. Sir, everyone is there. Our guest is also there. So shall we start
Right.
with the program?
Yes, madam, with your permission.
Yeah. Yes. Yes. Continue.
Right. Good morning, everyone. Greetings to one and all present here. I, Nagraj Shetty from LLB first year, TME's Lokmanya Tilak Law College, extend a very warm welcome to our today's guest speaker, Honorable Dr. Suresh Mane sir. Sir is a retired dean from my university. The value of college education is not the learning of many facts, but the training of the mind to think. We are in such a stage of education which needs continuous learning. With this context, today's webinar is organized by our prestigious institution, CME's Lokmanya Tilak Law College, for the benefit of all of us. Our guest speaker, Honorable Dr. Suresh Mane sir, will enlighten us on this topic, Indian Constitutionalism. As per Jim Rohn says, discipline is the bridge between goals and accomplishments. And as per Robert Lee, obedience to a lawful authority is the foundation of manly character. Before we go ahead with today's program, I would like to mention certain rules to be followed by all the students throughout the session. It is requested to all the students to keep their video and mic off during the session so as to avoid the disturbance. And it is also kind request to please type your questions in the chat box, and we shall be taking the same at the end during question and answer session so that the program is conducted in a smoother manner and there shall be no interruptions. I would now request our principal, Dr. Prakash Deshmukh sir, to kindly begin with today's program by briefing about TME and welcoming our guest speaker, Honorable Dr. Suresh Mane sir. Over to you, sir. Dr. Prakash Deshmukh sir.
Sir is getting some technical issue. He'll be starting soon. Nagraj Shetty, you continue, you skip this part and continue further. So once the sir joins, sir will commence his part at the end.
Okay. So let me go ahead and introduce our today's guest speaker. So we are very lucky to have Honorable Dr. Suresh Mane sir as a guest of speaker today in today's webinar. Advocate Dr. Professor Suresh Mane, sir, besides a socio-political activist analyst, doctorate in law from Mumbai University, he's a former law professor and head of postgraduate law faculty of Mumbai University, and has on his credit scholarly writing more than 13 books, 7 monographs, and more than 60 research articles on a wide range of issues such as constitutional law, economics, politics, social history, human rights, and Indian constitutional law. Some of his books have even been translated in Tamil, Gujarati, and Malayalam languages. Along with this, his writings on various subjects, being an eloquent public speaker, he has delivered several endowment lectures on various themes of national and international importance in universities, law schools, national institutions, and various schools, political and educational public forums in India as well as abroad. He is a visiting scholar of the Sage Colleges, Troy and Albany, New York, USA. Under his guidance, more than 20 research scholars have successfully completed their legal research for the doctoral degree in law of Mumbai University. While he was the professor at Department of Law of University of Mumbai has honored him with the title of Best Teacher of University of Mumbai in 2010. Currently, he is also the practicing advocate of Bombay High Court and the Supreme Court of India. Now, today's webinar topic is Indian constitutionalism, which is far more important than having a written constitution. Who else can make us understand this than the subject matter expert, who is Dr. Suresh Mane sir? So to start, I would request our today's guest speaker to enlighten all of us by commencing with today's session. Over to you, sir.
Principal Deshmukh, my student friends. Today morning we are discussing on a very important topic, and that is the Indian constitutionalism. You being a student of first year law and not the postgraduate where I taught for more than 25 years, I'll be very precise and clear, simple, so that you can understand the basic crux of the Indian constitutionalism. During the course of the deliberations, I hope there will not be any technical difficulty either from my side or your side. And in such a case, we will have a little bit break of either 1 or 2 minutes, whatever it is. And then we'll keep on continuing with our session on Indian constitutionalism. As a teacher, my motto of teaching, style of teaching has been always different. I followed the method of not giving an information to the students, but creating an interest among them to study a particular subject. And I know very well the large body of the students, they consider Indian constitutional law as the most toughest subject. Those who come from the background of the political science at the BA level, they enjoy this subject, but other, especially those who are coming from the science stream, they feel it is rather very difficult to grasp the subject, make a subject of the large complications. But from today's discourse, you will understand how the subject is so simple and quite interesting. And keeping in mind that these two objects, I will be delivering this lecture today. When we open the topic of constitutionalism or a constitutional law, three basic concepts are of very great significance. that is constitution, constitutional state, and constitutionalism. Now, many of you at this stage may not understand the differences between these three concepts. But as on today, I only just tell you that these three concepts are different, not the same, not the similar, and therefore they have their own connotations, implications, and importance. To begin with, the first concept, that's the constitution. This concept has been evolved through different stages, right from the Greek or Roman Empire, where certain orders of the kings were equated with the concept constitution, traveling the same idea in the 17th century in the United Kingdom, where King Henry II, he also equated his certain orders equivalent to the concept of a constitution. And thereafter, stage by stage, with the evolution of the modern state, the term constitution has come into existence. With the first written constitution in the history of mankind, that is the 1787, the Constitution of United States of America, the present world knows what constitution means. And therefore, after US Constitution of 1787, almost each and every state have their own written constitution or partly written constitution, not completely written constitution like the United Kingdom. But from these things, from this background, one thing you should know, and that's the first point, that a modern state cannot be without a constitution. Every state must have a constitution. Without constitution, state cannot exist. Having accepted this first proposition, the second proposition which comes, and that is, each country's constitution may be a product of evolutionary processes or a revolutionary process. Simply, it may be a product of evolution or revolution. And as you know very well, in the United States of America, you have famous American War of Independence that followed the formation of loose state called as the United States of America. That resulted into US Constitution. You know, the former state of Russia or Soviet Union. Soviet Union Constitution came into existence after the successful revolution of 1917. So in that state, the constitution was a product of revolution. And coming to the third model, if you look at the evolutionary process of United Kingdom, the UK Constitution, the English Constitution has come into existence by stages of evolutionary processes, right from the famous Magna Carta to Act of Settlement of 1701, whereby the British Parliament absolutely established its sovereignty. Now, having said so, let us come to the Indian Constitution. Whether Indian Constitution is the product of evolution or revolution. And simply you can answer it is a product of evolutionary processes. It is not a product of revolution. From several enactments, from the Indian Council Act of 1909 onwards, India has witnessed the constitutional reforms from time and again. And a major constitutional reform that took place after the three roundtable conferences, the United Kingdom in 1930, 31, 32, resulting into the formation of Government of India Act of 1935, that has been the backbone of the Indian constitutional law. Now, at this juncture, one more point you should note, and that is, few minutes back, I said that there cannot exist modern state without a constitution. Now, same proposition could be asked by some other question, that is, why the state needs a constitution? And if you answer this question, you will come across, you will find that whenever a new state comes into existence, it needs a fundamental law, a document, a charter called as the Constitution. And the global history gives several examples that whenever any state became independent from the foreign yoke, foreign dominance, it adopted its own constitution. And similarly, India was also in a need to have its own constitution on independence. And then from 1946 to 26 November 1949, during 2 years, 11 months and 17 days deliberations in the Constituent Assembly of India, that took place, that has resulted into the Constitution of India adopted on 26 November 1949. Now, as I refer to the deliberations in the Indian Constituent Assembly, for the simple reason that to grasp the contents of a constitution, any constitution, you need to know the background of the constitution in which it was adopted or drafted. Without knowing the sociology, history, politics, geography of any state, the human stock of that state, you cannot understand the constitution of that state, why it has followed a particular model or why it has not followed a different model. That could be answered only by knowing these basic facts, the background facts. And to be very precise, the background facts of Indian Constitution, we are very familiar now, that India had several socio-cultural, religious institutions that were basically against the spirit of modern liberal values of democracy. For example, liberty, equality, fraternity, and justice. India had a historical burden of several outdated socio-cultural religious institutions. Followed from right from the ancient practices to medieval practices. In such a situation, the task of the drafting or adopting the Indian Constitution was not an easy. It was a difficult task, Himalayan task. And therefore, the framers of the Indian Constitution unanimously adopted the agenda of restructuring the Indian society through Indian Constitution. Now, when I am saying restructuring the Indian society, that brings me to an issue of what are the aims of the Constitution. And if you discuss the aims or the objects of any constitution, legally speaking, or speaking in a legal sense, any constitution is expected to provide a basic structure of governance. It should contain minimum rules of governance. It should lay down the minimum structure of a governance, the powers, the limitations on the governing structure. To be very precise, the document which claims to have an authority of the Constitution should provide a selection of rules, not the collection of rules. Few selected rules relating to governance. That should be the object of any constitution. Keeping in mind this object, US makers of the Constitution, makers of the US Constitution, they followed this trend. So US Constitution is a very precise, brief, concise. Because before the US Constitution makers, there was no agenda of a restructuring of US society. But Indian Constitution makers had an agenda before them, and the agenda of restructuring the Indian society. As a result of it, the Indian Constitution has become a bulky boundary. Because when everything is let down and not left in the form of conventions, Constitution is bound to be lengthy and bulky. And therefore, the Indian Constitution providing for each situations, the circumstances, laying down for almost all the visualized situations, is bound to be a bulky, lengthy, with so many provisions. And therefore, Indian Constitution is one of the lengthy, detailed constitution in the world, for which it also received a criticism. But why it is lengthy needs to be understood. As I was saying, the Indian Constitution is a national charter. It is a fundamental law of the land. It is a basic document of a state. And when I say it is a national charter, national agreement, adopted by the people of India on 26 November 1949, to create a new state premised on the ideals laid down in the preamble of the Constitution. And you know what are the ideals laid down in the preamble of the Constitution. The state committed to justice to all, based on the liberty, equality, and fraternity, the modern values of liberal democracy, opposed to the ancient and medieval several customs, taboos, and ways of life of Indians. And therefore I said, Indian Constitution, strictly speaking, in accordance with the terminology of a constitutional law, it is not only a legal document. Now here I must also explain to you that a constitution is supposed to be only legal document, laying down legal rules governing the political structure, the power structure. But as I said, in the middle of 20th century, when the founding fathers of the Indian Constitution sat together to draft the Constitution, at that time, almost all the principles of the constitutional law were well settled down. What constitution should contain and what constitution should not contain. What should be included and what should not be included. That was well settled down. In this scenario, the founding fathers' quest, desire, objective, to build up a new egalitarian society definitely needed a fundamental law based on modern values. And therefore, a renowned authority on the Indian constitutional law, led Professor Granville Austin from United States of America. In his book, he has rightly said that the Indian Constitution is the first and foremost a social document, not a legal document. It is a social document. Why? According to him, because it aims to a social revolution in India, social transformation in India, social change in India. And therefore, Indian Constitution is not merely a document of governance. It is a powerful weapon of socio-economic change. And therefore, it is a multidimensional. Therefore, it is not limited strictly to only legal rules, but it has also accommodated the aspirations of the people of India and the structure which has to meet out these aspirations of the people of India, the millions and the millions of people. And therefore, as I said, this constitution also provides an agenda for the future. The constitution also provides that what kind of society, state we would like to have, what kind of the values in a political democracy we would like to appreciate besides the power mechanism or the power structure in a constitution. And therefore, Indian Constitution is a novel. It is innovative in its own nature. And therefore, it is one of the ideal constitution in the world. And so most of the third world countries, they followed the model of the Indian Constitution, describing one of the best constitutions in the world. Having said so, let us switch over to basic characteristics of the Indian Constitution. And to begin with, a very simple first character, that is, it is a written constitution. Now, law students normally read in a textbooks that there are two types of the constitution. One is a written and one is a unwritten. And it is also a fashion for several writers, authors, to present English constitution as a model of unwritten constitution and other constitutions in a one box, that of written constitutions. But as a student of a constitutional law or a teacher of constitutional law for more than 25 years at the postgraduate level, let me tell you, in the world there is never a perfect written or perfect unwritten constitution. You cannot have completely written or completely unwritten constitution. US Constitution is not completely written. It is supplemented by subsequent developments, either from the amendments or by the judicial pronouncement. Indian Constitution, most of what is written, but certain conventions, unwritten forms, further supplemented by judicial pronouncement and the constitutional amendments. So constitution making is a never-ending process. It is a continuous process. It is a continuous process. On the other side, the Constitution of United Kingdom is also not unwritten. It is a partly written. Many students, teachers, writers, authors on Indian Constitution or books of Constitution, they simply say British Constitution is unwritten, which is wrong. British Constitution comprises of two things, written and unwritten parts. Magna Carta is the written part. Act of Settlement of 1701, that is the written part. So in English Constitution, the large volume of the Constitution consists of conventions, unwritten part. But few parts are written. Same applies to the Indian Constitution. The larger body is written, but some are the issues still governed by the conventions. Constitutional amendments supplement the existing structure. Judicial pronouncement, the supplements, strengthens, sometimes weaken also the constitutional structure. And therefore, constitution making is a never-ending process. It is a continuous process. And therefore, we simply can say the Indian Constitution is written, because most of the provisions are in a written form. Secondly, as I said, the background in which the Constitution came into existence is of pivotal importance. Prior to the adoption of the Constitution, India's familiarity with the political system of governance was to the British model, because India was governed by the Britishers. More than 150, 200 years, rule of the British Empire created, articulated, institutionalized certain institutions. And one of them was the unitary state, the concept of unitary state. Now, having the background of a long unitary state, from 1935 onwards, even under the British rule, India went for federal framework. Federal framework. Federal framework means the power is divided between the center and the states. And the unitary framework means power is entirely concentrated in the hands of union or the central government. Now, Indian Constitution had an experience of a unitary model as well as the federal model from 1935 onwards. So the framers of the Indian Constitution adopted both the models in the Indian Constitution. So it is neither federal nor unitary. Now, unitary constitutional model comes from the UK and federal constitution model comes from the US. Now, USA constitution being the first written constitution in the world, and that to federal constitution, naturally it becomes a model for all other federal constitutions. But whether Indian constitution makers have accepted the same model of US federation, answer is no. Whether the Indian constitution makers have accepted the same model that of UK unitary model of a constitution, answer is no. Indian constitution makers adopted the policy of pick and choose the best characters of the world constitution. And here comes an art of constitution making, the constitutional craft, which was exhibited by Dr. Ambedkar on the floor of the Constituent Assembly time and again. Indian Constitution reflects the blending of both the models, unitary and federal. So it is neither unitary nor federal, but it is a both. And summing up in the Constituent Assembly, Dr. Ambedkar said, during a peacetime, it is the federal. And wartime, it is unitary. So when the nation's requirement is of unitary model, it will turn into unitary model. Otherwise, it will work as a federal. Now here, again, one more characteristics you should remember. Of course, when you go to LLM and other postgraduate or higher studies, you will study this issue more in detail, and that is, in United States, US Federation is called as indestructible federation of indestructible states. US Federation is indestructible state of indestructible states. It means states cannot be changed. Their boundaries cannot be changed. Population cannot be here and there, as we have the issue of Belgaum should come into Maharashtra or not, or a separate state should come out of Maharashtra as a Vidarbha or not. These are not issues in United States. State has its own confirmed population, boundary, everything. So it is indestructible federation of indestructible states. Ours is India's indestructible union, destructible state. Indian Federation is, it is a union as described in Article 1 of the Indian Constitution, It is a union, not a federal. It is a union, but of destructible states. In other words, Indian states can be changed, modified, abolished. And that recently we have witnessed in the case of Jammu and Kashmir. Now the state has become a only union territory, no more exists as an independent state. Or a state like Sikkim, who became a part of India in 1973-74. And therefore, India's federal framework is different from other federal constitutions in the world, like US, Australia, Canada. Indian constitution is a different one. And therefore, here at this context, the emergency provisions which have been provided in the Constitution of India, they were severely criticized and attacked in the Constituent Assembly as well as outside the Constituent Assembly during the process of the formation of the Indian Constitution. Some of the members on the floor of the Constituent Assembly, like Professor H.V. Kamath and K.T. Shah and others, they strongly objected to these kind of the provisions like emergency, state emergency, imposition, the governor rules in the state or the central rule in the state. They opposed, saying that it is against the spirit of a federal democracy. But founding fathers, in the background of the partition of India, a terrible trauma experience of a partition and the disruptive tendencies, keeping in mind the challenges of such forces in the future. They had endowed the center with this extraordinary power that is called as the emergency powers. These emergency powers exist in almost all the constitutions. Because every state, some or other time, faces such kind of a critical situation where you need to have this kind of a power with the union. But the Indian Constitution provides such powers in a so detail, so it became a subject matter of criticism. But as we know very well, why such emergency powers are of a vital significance, keeping in mind the object of keeping intact together the Union of India. The significance of this power you can understand in the context of certain resolutions that were passed by certain states asking for more autonomy, like state of Punjab, state of Jammu Kashmir, and some other states. They also in the past have passed the resolutions demanding more autonomy. Now, founding fathers of the Indian Constitution had before them a challenge to keep India united, keep it together. For that, they required this kind of an extraordinary provision, like emergency situations. Sometimes these are abused, misused by political parties, by the governors. That is a constitutional politics. That's not a constitutional theory. That is not a constitutionalism. That is the politics of constitution. Apart from this misuse by certain governors or the politicians, the object of providing such a provision was to hold the country together. And therefore, Dr. Ambedkar rightly said, Constitution is a federal, but in peacetime, it is unitary, during a war time. When the situation demands, immediately it turns into unitary constitution. A country having a vast quantum of a plurality, divergent factors, the diversity, holding country together as well as to take the country on the path of the progress with suitable political model. That was a challenge. So the constitution makers, along with the federal framework, they gave extraordinary powers to the Union of India with powers of emergency. That is also a unique feature of the Indian Constitution. As I said again, the Constitution develops in the background scenario. Socio-political background is of vital importance. And during the British period, people of India's familiarity with the parliamentary system of governance, democracy. Naturally, the founding fathers adopted this kind of a model in the Constitution of India. So we have the parliamentary model of democracy. So India adopted the parliamentary model of democracy, but not strictly based on the parliamentary democracy model of UK. Because UK's parliamentary democracy, where the institution of kingship or the queen, hereditary institution, that kind of a model is not adopted by the Indian Constitution. So without the institution of the king or the queen, we have adopted the parliamentary model of UK, wherein you have the cabinet responsible to the entire parliament or the state legislature. And the decisions of the parliament or the state legislatures are taken in the name of doctrine of a collective responsibility. Explaining this character, again, Dr. Ambedkar on the floor of the Constituent Assembly while introducing the draft Constitution on 4th November 1948, explained in detail, saying that why we have rejected the presidential model of US and why we have accepted the parliamentary model. And during the explanations, he said that presidential model stands for the stability, but parliamentary stands for accountability. We have preferred accountability to stability. We accepted the model of accountability rather than stability. And therefore, those who always talks about elections time and again, they argue that here is the time to go or switch over to presidential model. In presidential model, there is a least accountability of the executives. Whereas in a parliamentary model, you have the more accountability, the daily accountability, day-to-day accountability. And you know what is accountability? When a parliamentary session is in a progress. If you have watched the parliamentary proceedings, how the executives are answerable to the country, to the parliament, on each and every question of national or local importance. And therefore, founding fathers, while preferring a model of a parliamentary democracy, they conceived that accountability is more important than the stability. And therefore, they followed the model of the parliamentary democracy. But here again, I must bring to your notice that although we have accepted a parliamentary democracy model, It is not a parliamentary democracy model represented by the UK Constitution. In UK Constitution, there is a doctrine called as the doctrine of parliamentary supremacy or parliamentary sovereignty. It means Parliament is supreme, Parliament can do anything, and nothing could be challenged against the Parliament. No fundamental rights, although there is a Magna Carta in the United Kingdom. Now, founding fathers of the Indian Constitution, here again, they departed from the British model. And they did not confer an absolute supremacy on the Parliament of India. So under Indian constitutional framework, our Parliament is not supreme. Remember again, here, many people speak right loosely saying that Parliament is supreme because it represents the people's will. No, legally incorrect. Legally, our Parliament is not supreme. Because Parliament's any decision can be questioned before the courts. So we have another characteristics of our Constitution, that doctrine of judicial review. And this doctrine of judicial review is an important character of US Constitution. But this principle also was not originally crafted in a US Constitution. No. It came into existence by a historical pronouncement of the US Supreme Court in 1803 in a very, very famous case named as Marbury versus Madison. Marbury versus Madison. Through this case law, judgment of Marbury versus Madison, the doctrine of judicial review became an integral part of the US Constitution. So the founding fathers adopted these two different models together. Parliamentary supremacy model from the UK and the doctrine of judicial review, the model from the US Constitution, bringing together, putting it harmoniously, and creating the system of checks and balances. So Indian political system of a parliamentary democracy is a system of checks and balances. System of checks and balances mean when parliament goes wrong, the judiciary is there to correct. And when the judiciary is committing certain wrongs, in the process of delivering its judgments, the parliament or the legislatures, central legislature, there is to correct. And therefore, under Indian constitutional setup, neither courts are supreme nor parliament is supreme, but the constitution is supreme. All organs of the state, they derive from the constitution itself. And therefore, under Indian constitutionalism, parliament is not supreme. Courts are not supreme, but the constitution is supreme. And therefore, this is also one more unique characteristics of Indian constitution that needs to be noted. Now, having highlighted this, some of the characteristics, there are many more small, but I just focus on these 2-3 importance of constitutional significance. Having described these characteristics, highlighted these features, the first part of the Indian Constitution relating to the citizens, which is currently under debate, hotly debated topic, with the passing of Citizenship Amendment Act of 2019, now, although first part of a constitution provides for the citizenship, naturally, India became independent. There was a partition of the country, huge migrations, some people staying abroad. So the question of who is a citizen and who is not a citizen. Naturally, this question became of equal significance. So at the time of the constitution, few provisions were laid down. And the issue was left to the parliament through special enactment. And therefore, we have a special enactment called as the Indian Citizenship Act of 1955 that regulates the citizenship issue. But as I said, in 2019, citizenship issue became a subject matter of a great controversy with the passing of 2019 amendment. And this 2019 amendment, the Citizenship Amendment Act 2019, that has provided now a citizenship to the people of Pakistan, Afghanistan, and Bangladesh, who are the victims of religious persecution, other than the Muslims or the Rohingya Muslims, or even the Tibetan Buddhists, or like that, or even other than the issue of Sri Lanka Tamils. Keeping aside these issues, Tibetans or Rohingya Muslims or the Sri Lankan Tamil, the decision has been taken by the Indian Parliament to allow the citizenship to people migrated to a certain date from these three states who have been a victim of religious persecution. Of course, the Citizenship Act has been challenged in the Supreme Court, and the issue is pending before the Supreme Court of India for a final decision. After the citizenship, the vital part of the Indian Constitution is the fundamental rights. Now, in the whole body of the Indian Constitution, two parts are of great significance. First is the fundamental rights, and second is the directive principles of state policy. And this covers so many articles, almost from fundamental rights 12 to 36, and directive principles from 37 to 50, 51. So these parts are of a very great significance, importance, and students should study them thoroughly in depth so as to understand the larger part of the Indian Constitution. Here again, precisely, so long as we had a Britishers rule of British, Indians were without fundamental rights, because you cannot ask anything against the British Parliament, because British Parliament is sovereign, so you can't ask. So Indians were without fundamental rights prior to the Constitution. So theme of fundamental rights, having a body of fundamental rights, bulk of fundamental rights, was a predominant theme during a freedom struggle. So Constituent Assembly was determined to have a fundamental rights in the Constitution. But so many rights, different rights, variety of rights. So finally, Constituent Assembly came to the conclusion that certain rights can be made justiciable and certain rights could be made as unjusticiable, but fundamental in the governance. And so this bundle of rights were categorized, bifurcated in two parts. First is the fundamental rights, and second is the directive principles of state policy. To describe again these two parts, the fundamental rights contains the civil and political rights, and the part 4 contains the economic and cultural rights, collective rights. Now, while granting the status to certain rights as the fundamental rights, what was the criteria? As I said, these fundamental rights guaranteed by the state to the citizen, gift of a state to the citizen. First thing we should know, they are not absolute. No right guaranteed by state constitution is absolute. Always it is a subject to restrictions. Now we call it as the reasonable restrictions. And therefore, let us remember, all fundamental rights guaranteed to the citizens are subject to reasonable restrictions. Second, since all these rights are guaranteed by the state, they are available against the state only, not the private person. They are available against the state, not against the private person. Because these fundamental rights are against the state, not the private individual or collective body. Third, Indian Constitution has provided a mechanism to enforce these fundamental rights. Fundamental rights are enforceable. Enforceable means if state violate that fundamental right, a citizen has the right to go to the courts. Under 32, directly to the Supreme Court. Under 226, to the High Court. So Article 32 and 226 provides the constitutional remedies. Remember again here, Article 226 scope is much bigger than 32. 32 provides a remedy only for violation of fundamental rights and no any other right. Whereas under 226, besides fundamental rights, even for the violation of any other right, citizen can go to the High Court. So 226 is much wider in scope than the Article 32 of the Constitution. But when 32 was adopted, again on the floor of the Constituent Assembly, Dr. Ambedkar rose and said, if I'm asked to point out a particular article which is of so importance that without this constitution is meaningless, I would say Article 32. That much importance was attached to Article 32 because that gives itself a fundamental right to the citizen to go against the state. Now, at this point, again, you need to understand the concept of state here, the definition of the state. And the definition of the state is defined in Article 12 of the Constitution. That is the opening gate for the chapter on fundamental rights, part 3 of the Constitution. And this Article 12 categorically says, in this part, unless the context otherwise requires, the state means the government and Parliament of India, the government and the legislature of a state, or any other body within the territory of India or under the control of the government. Now, right from 1950 to today, this definition of state has been widened to such an extent that even a cooperative housing society is also state now. Apart from local bodies, panchayat and all banks and the local body like Bombay Port Trust or others, they all are state, university. And therefore, state has been interpreted so liberally by our Supreme Court that almost each and every rule making governing institution comes under the umbrella of Article 12. So you have the fundamental rights against all of them. Now, as I said, these fundamental rights includes a very important rights. You can go through one by one. But just I would like to bring to your attention to Article 21. And Article 21 guarantees you protection of life and liberty. No citizen shall be deprived of his life or personal liberty except in accordance with the procedure established by. Take this simple article. How many words? Not more than 25, 30. But this article is a product of two constitutions. One is the US and second is the Japanese. The first part of 21 comes from the US and latter part comes from the Japanese, except in accordance with the procedure established. Here, founding fathers rejected the concept of due process of law that had in US Constitution. Because this concept of due process of law created a manifold problems before the US government. So founding fathers adopted the convenient part from the Japanese Constitution. That is, except in accordance with the procedure established by law. Now, what do you mean by law? Law means any legislation? Yes. In the initial stage of the working of the Constitution, our Supreme Court construed law mean, yes, state enacted law, any law. Any law. But now the concept of law has undergone a radical change. It doesn't include any law. Now law means reasonable, just, fair. That is called as the dynamism of the constitutional law. How constitutional law undergoes a change. And here you will find a difference. Any law means any law enacted by the state. And that is the first case of 1950, A.K. Gopalan's case. If state has passed any law, that is the final. That is final. Now it is not the case. The state law is under challenge. Law needs to meet certain criteria. It has to be fair. It has to be reasonable. It has to be known to the people on a large scale. So what is the meaning of law? And law is defined in Article Indian Constitution 12.3. Law is defined. And therefore, what is a positive law in 1950? It is not a positive law now in 2020. Now, Article 21 is very small, brief. But look at the case law which has flown from Article 21, and still 21 is under judicial exploration. Article 21A, now right to education. Part of 21. Even right to have a clean water, safe drinking water, clean environment. During a corona crisis, you can file a writ. Student of law, you can file a writ. State is a duty bound to provide a clean, safe living environment. not hazardous, not dangerous to human life. Series of rights to the minorities, abolition of untouchability, basic freedom. And on the issue of basic freedoms under 19, freedom of expression. You have a recent case law coming from the Supreme Court in the matter of JK, that is Anuradha's case, where the internet system was stalled in the JK during the process of abrogation of 370. And the Supreme Court came out with the finding. Of course, it came very late because 100 days, there was no internet, there was no telephonic connections. But anyhow, Supreme Court came late and delivered a judgment saying that citizens have a right to access to internet. In a modern era, people cannot live without thinking an idea of internet, social media. So freedom of speech and expression, although we have rising cases of contempt of courts on the one hand, second cases of sedition under 124A of IPC, whereby Indian states have been deeply involved in charging the citizens with this kind of an offenses. In certain cases, definitely genuine, but in certain cases, without its genuinity, the freedom of speech and expression, as explored in Article 19, is of pivotal importance here. Coming to part 4, and here I would like to focus on one or two issues. I'm not going in detail what contains in Article 1, 2, 3, 4, 5, 6, 7, not all that. Part 4, as I said, unenforceable part, not justiciable. It means whatever is provided in a part 4, if the state fails to implement it, citizens have no right to go to the court for its implementation. So it is called as non-justiciable. But if you read the language content of Article 37 very well, it connotes they are not enforceable, but they are fundamentally in governance of country. They are basic to the governance. And state is the duty bound to take them into account while making the laws. So it is the duty of the state to take them into account while enacting the laws. Earlier, this 37 article was also not interpreted properly by the judiciary, the Supreme Court. In the initial stage, the Supreme Court said, Part 3, fundamental rights are more important than the directive principles because Part 3 is enforceable. So Supreme Court formulated the theory of subordination of directive principles of state policy. And this theory governed right from 1950 to 70, 75. So almost 20, 25 years, the theory of the subordination of directive principles of state policy killed the constitutional significance of directive principles. Founding fathers on the floor of Constitutional Assembly, they had said, these directives are of vital significance, futuristic agenda of Indian state, relating to the economic transformation of society, living wage, no concentration of economic power in the hands of few people. They are of very vital significance. Although citizen cannot go to the court for its enforcement, state is the duty bound to take into account, implement them, consider them while making the laws. But Supreme Court also till 70, 75 neglected directive principle. To the directive principle jurisprudence in the Indian constitutionalism. After 1970, slowly to
Sorry, we can't hear.
Yeah, just wait, just wait. There's been some network connection error.
Okay, okay. Thanks.
Sir, you are on mute, sir. If you could just enable your mic.
Now, okay.
Yeah, it's fine, sir. Thank you.
I think internet is also tired saying that now you have to sum up. I know when we delivered for LLM, our lecture used to be a 2 hours and
Yeah.
continuously we used to speak for 2 hours. And I never had a textbook in my hand while delivering the lectures. I never refer the papers. I never take even a bare act in my hand because I have taught for 20 years, so I can go to in details. So in summing up, only I will sum up this part and the last part is of amendment, and then we will conclude. As I said, directive principles. Now the trend is the judiciary is importing directive principles into articles contained in the fundamental rights, giving effect to certain directive principles of the state policy. But that does not mean that all directive principles have become alive or the effect has been given. No. On the contrary, you can visualize that the Article 38 and 39 that categorically says that the economic power, the resources should not be concentrated in the hands of the few people. But with the emerging era or the emerged era of the liberalization, globalization, and considering the number of increasing number of millionaires, billionaires, and trillionaires in our Indian society, there is a huge concentration of economic power in the hands of the few people. And thereby certain directives have been completely nullified. Even an eminent scholar on Indian constitutional law, as I said, Granville Austin, he has charged the Indian Parliament by saying that there is a silent conspiracy to not to implement directive principles of the state policy. And here he pointed out the original Article 45 in the Constitution. Original Article 45 provided for the free and compulsory education to all children below the age of 14 years. But now amended 45, 46, you read that doesn't provide for up to 14 years, not before 6 years. So your right to education is restricted to 6 to 14 years. So original 45 is also bypassed. And here that Austin says, although power has been changed, the power structure has been changed in India, but the mentality of the colonial nature is not changed. Britishers never wanted to educate all Indians, and the Indian governments also never want to educate all Indians, because if they all are educated, problems will be there. So this way, even directive principles of state policy have not been uh, properly accommodated in our parliamentary activism or judicial activism that has caused the huge damage to our constitutionalism. Last part which I'm speaking, and that's the amendment part. As you know, the amendment again is a very hot issue, contested issue. Parliament always asks that we are elected representatives of the people, represent the ultimate will of the nation. So ultimately, we must have a last say in the matter of what constitution is. For that, Indian Parliament brought several amendments. And a 42nd amendment was one of the biggest amendment that drastically changed the constitution itself. And there was tug of war between the constitution, that is the judiciary, and the parliament. And when parliament asked for the unlimited power in 1980, there is a judgment of Minerva Mill. But before Minerva Mill, you have a very famous judgment of Keshavananda Bharati, that is 1973. Before 1973, Parliament sought to have an amendment giving unlimited power to the Parliament to amend the Constitution. That was not allowed by the judiciary, saying that yes, you can amend any part, but not the basic structure. And what is the basic structure? That will be decided by the judiciary, not by the Parliament. So here, the Supreme Court has the last word in the matter of amendment and not the Parliament. So our Parliament doesn't have unlimited, unfettered powers to change the Constitution. In 1980, in a Minerva Mill case, the Supreme Court nicely expressed this ground reality by saying that Parliament is not a donor, it is one of the donee. Donor is the Constitution. Parliament is a donee. So donee cannot become a donor by acquiring, exercising the powers of unlimited nature. So under Indian constitutionalism, our parliamentary system, although has a vast powers of union in certain cases, but not powers of such nature which goes against the basics of the Indian constitutionalism. And that is one of the limitation on the Indian Parliament, which continues or which will continue so long as the doctrine of the basic structure survives. And the day by day, with the judicial activism, and now the system of collegium, where judges are appointed by the judges only, the Parliament will not be in a position to bypass very easily or so easily the doctrine of the doctrine of the basic structure. And therefore, our Indian constitutionalism developed from 1950 to 2020, almost 70-year journey. 70-year journey is not a long journey in the country like India, consists of great variety, plurality, diversity. But whatever we have traveled in the last 70 years, it is a remarkable journey. And the Constitution has been so successful in holding the country together. And here I remember one professor from the United States of America, Clayton Rossiter. Clayton Rossiter, who is no more now, I think he died 2 years back, from Cornell University of US, and he said, I have taught the political science for the years, and I have seen many constitutions working with the prerequisites. But I feel there is one exception. An exception is the Indian Constitution that works without prerequisites. Without prerequisites in adverse condition. And therefore he says, here is the splendid exception to all our generalization. So Indian Constitution is a remarkable, splendid exception, a historical document, living document, lives with the growing living society of India. With these few words, thanks to all of you. Thank you very much. Thanks to principal and the college students all. Thank you very much.
Sir, it's indeed a great pleasure, sir. I mean, it's so much of thought-provoking and so much of knowledge, even as you rightly said, sir, without even referring to any other books. Your experience is so much, and there is a lot to give for us, but unfortunately, with the time constraints, you could deliver only this much. But it's really overwhelming session, sir. Now, I would request Prakash Deshmukh, sir, to just to, since you were, we missed your, some few words, sir. If you could just help us to, brief about our today's guest of honor.
Please, sir. Please. Are we able to hear me now?
Yes, sir. Yes.
Hello.
Yes, sir. We can hear you.
Dr. Prakash. I, Dr. Krishna Deshmukh, principal of the TMV Lokale Tilak Law College, Kharghar, Taluka, Panvel, Jilla, Raigad. Honorable Sri Dr. Suresh Manik, retired Dean of Bombay University, Law Department. Today's webinar Chief Guest Speaker. Honorable Dr. Deepak J. Tilanji, sir, President, and Chancellor of Maharashtra Vidyapith, Honorable Dr. Mrs. Praniti Rohit Shelagi Madam, our Khargas campus mentor, Learned Mahesh Dhogaonkar sir, our Khargas campus in charge, and Mrs. Varsha Bhatve Madam, coordinator, Adjutant Bhupender, and my dear students and staff. Tilak Maharashtra Vidyapith, TMV, established in 1921, is recognized by the government of and deemed to be university. And the second of 1956. Since 1987, the university is going to complete the century on 6th of May 2021. We offer programs in multiple disciplines such as Ayurveda, Sound School, Social Science, Modern Science, Professional Skills, Management, Health Sciences, Law, and Distance Education. Lokmanya Tilak Law College was established in the year 2013 and approved by the Bar Council of India for BA LLB 5 years and LLB 3 years. Courses are offered. In its pursuit of excellence, our institution aimed at not only the professionalism, but also the ethical values and social responsibility. And hence, the curriculum is designed to transit the boundaries of academicians to be relevant to the changing Puritan social requirements. In this coming semester, we are organizing a trial court, police station, jail visit, and high court visits to get the practical legal knowledge to our students. Instead of that, we organize the webinars on the different topics by high dignitaries, such as the Consumer Amendments Act 2019 by Honorable Justice Ashok Bangale sir, retired the chairman of the State of Maharashtra Commission. The criminal administrations by Honorable Justice of March 2021 organized an inaugural Honorable Mrs.
Voice is breakable. Voice is breakable.
Principal District Judge and Session Judge, Raigad District at Alibaba. And also Honorable Mrs. Another webinar organized our
Prakash sir, your voice is breaking.
chairman. Please. Chairman, Sri Rajesh Asma, Panvel District Raigad, on various topics by their different judges. I welcome our students today's program, chief guest and speaker of webinar, Honorable Dr. Suresh Malik, retired Dean of the Bombay University Law Department. I also welcome Honorable Deepak J. Tilak sir, President, Chancellor of Tilak Maharashtra Vidyapith, and our Khargas campus mentor, Honorable Dr. Mrs. Praniti Rohit Tilak Madam, Learned Mahesh Dhogaonkar sir, our Khargas campus in charge, the Principal Dr. K. Sriram Chandra Murthy sir, Head of the Pune Law Department, and Learned Coordinator, Mrs. Varsha Bhatve Madam, all my beloved assistant professor, staff, and dear students. Please.
Thank you so much, sir.
Read.
Yeah, you could hear you. Thank you so much for your brief introduction, sir.
Because of sorry, I have to say sorry because of some disturbance in voices. Please continue.
We understand, sir. It's all about because of the technical issues. So as part of our question and answer, we would like to move to the next round. So just to quote a small statement here, minds are like a parachutes and they only function when they are open. So dear audience, I want you all to be open up and ask your question if you have any.
Shall I ask?
Yeah, if your audio is good enough to talk, please unmute and you can ask. Hello. So I have a question from Rohit. Sir, so do you think in recent times sedition is being misused by government? When people talk about inefficiency of the government, what about their right of freedom of expression and opinions? What are your views on it?
Mane sir, please
Uh,
unmute yourself.
is he there? I can't see him.
Yes, now can?
Yeah, now, sir.
Yes, sir.
Sir,
Audible.
have you got the question, sir? You want me to
yes,
repeat?
I,
Okay,
I
sir.
followed the question,
Okay, sir.
but that mainly falls in the domain of criminal law, not a constitutional law. But again, bringing the same question in the constitutional law under Article 19, freedom of speech and expression, we can deal with this question. And certainly I agree, in a recent past, there have been a misuse of two things. One, Article 124A, that is the sedition. And second, the invocation of UAPA and even NSA, National Security Act. Now we have the sufficient data that there has been humping cases of misuse of UAPA, National Security Act, as well as 124A. And it is the aim to stifle the criticism. And therefore, recently, the Supreme Court of India has taken a note of such dissenting voices. And the Supreme Court has come out with the verdict saying that citizens have right to give their opinions, views, of course, in a fair manner, in a reasonable manner, within the restrictions of 1912. So now it is absolutely clear, since last 4 or 5 years, there has been rampant increasing cases of misuse of 124A. Yes, next.
Yeah, I hope this has answered correctly. I think Rohit, I think you understood the answer. Anybody has any other questions, sir? Someone wants to unmute.
Respected Mane sir, I want to know actual 121 Act, what you are explained, and about regarding the 38 and 39. Kindly explain, please.
38, 39 and?
38 and 39, sir.
Yeah. If you look at these directives of 38 and 39, these are the guarantees to the citizens by the state, but in the form of non-justiciable provisions. Basically, they are related with the economic issues. If you look at the 38 and 39, these directives categorically says that the state should initiate certain actions. And these actions of securing a social order in the promotion of welfare of the people, that could be related even to the current context. Then certain policies to be followed by the state. Now, these two articles are basically relating to the welfare of the people, welfare of the state, and economic model of the state. Economic model of the state, although initially it was not explained anywhere in the text of the Constitution, but with the 42nd Amendment Act of 1976, we have the socialism as the ideal model. And in consonance with the socialist model, if you look at this 39C and D, B and C, that the ownership and control of the national resources, material resources should be equally distributed, should not concentrate in the hands of the few people. Second, the operation of the economic system does not result into the concentration of a wealth, then equal pay for equal work. So these are the welfare measures. But as I have just touched briefly, that with the agenda of liberalization, privatization, and globalization, with the model of economic reforms, now we have been switched over to the crony capitalism. And technically, although word socialism or socialistic pattern exists in the text of the Indian Constitution, we are switch almost to the crony capitalism and slowly to the process of capitalism. That is an unfortunate story, but it is a factual.
May I ask question?
Yes.
Good afternoon, sir. I am Sandeep Sarda, LLB1 Pune.
Yes.
Sir, this is with reference to the recent judgments given by Delhi High Court in relation to pandemic matters.
Yes.
Is it not judiciary is entering into the shoes of executives? Because specific instructions of issuing oxygen, so specific quantitative oxygen.
Understood.
Yeah. Yes, sir.
Apart from Delhi High Court, there have been judgments from Allahabad High Court and a very strict judgment of Chennai High Court, Madras. So, 3 high courts, even Bombay High Courts have now stepped in. Now, directing the state to provide these basic things is not an encroachment on in the field of executives or the legislatures, because when the state has guaranteed you a life, protection of life under Article 21, then who has to protect it? State has to protect it. And if the state is failing in protecting, then who has to tell the state? The court has to tell the state. Judiciary has to tell the state. And therefore, recent directions given by either Allahabad or even a Delhi High Court or Chennai High Court and now the Supreme Court go for national lockout. These directions are within the purview of judiciary and not an encroachment on the field of the executives. That is one. Secondly, when the citizens feel helplessness, who is going to help the citizens? And under our constitutionalism, if the government is not coming to the rescue, then the courts are there. So court is doing its job, nothing new, nothing wrong. Next.
Thank you, sir.
I think Gojri, your question is government who is running the country is responsible for constitutional rights of the people. I think this is answered. This is covered in this answer which sir had given right now. Sir, one more question from the circuit. Does freedom of speech give a citizen to make any abusive statement about the PM in open forum? You want me to repeat, sir? Hello, Mane sir, are you able to hear? Mane sir, you there?
Some connectivity issue from Anis's side. Let's wait for some more time.
Yeah, please.
Coordinator, let us conclude now.
Yes, sir.
Yeah.
Sir, there is a small question. This is the last question, and we will be ending the question and answer after this. Does
Yes.
freedom of speech give a citizen to make any abusive statement about the PM in open forum?
Now, abusive means what exactly? That is a debatable point.
Yeah, correct.
Because what is abusive and what is not abusive, that is needs to be determined from the factual basis, factual matrix. That is one. Second, criticizing the high functionaries, criticizing is within the ambit. Criticizing, yes, our PM is not doing okay, fine. But if you use the language of abusing nature, that brings you into a trouble. So that is called as freedom of speech and expression within the reasonable limits. So abusing to any high official, high official. Now, Madras High Court's criticism against the ACI. Now, this is not abusive. On the contrary, it is a constructive criticism. So constructive criticism is always welcome, whether it is against the PM, CM, DM, anybody. That is always welcome. But abusive criticism is somewhat, if it crosses the border of reasonable restrictions, that becomes an offense.
Right. Thank you so much, sir. So this is that was the last question of as round of a question and answer session. The mediocre teacher tells, the good teacher explains, the superior teacher demonstrates, the great teacher inspires. Thank you so much, sir. Today's session have not only enlightened our knowledge, but also boosted us morally. It was an honor for all of us to hear from you, sir. Now, I would like to give a vote of thanks by Assistant Professor Sapna Jaiswal, Madam. Sapna Jaiswal, Madam, yeah, over to you.
Very good morning to all. I'm Assistant Professor Sapna Jaiswal from PMV's Lokmanya Tilak Law College, Kharghar. It gives me an immense pleasure to give a vote of thanks to all the dignitaries present here for this successful session. I would like to thank on my behalf and on behalf of this institution to our guest speaker, Honorable Dr. Suresh Mane sir, who have spared time from his busy and honored this event with their illuminating knowledge. Sir has covered many basic facts about the Indian Constitution, and sir has also made us understood the vision of the founding fathers of the Indian Constitution in adopting the different features from the different countries. Sir has also highlighted some important characteristics of the Indian Constitution like parliamentary form of government, directive principle of state policy, fundamental rights, and amendment of the Constitution. Sir, this was really very informative and rather very interesting session, sir. Thank you so much, sir, for enlightening us. And I'm sure it will help our students in present and future also in showing them a new path. Extend my gratitude and cordially thankful to the Honorable Chancellor Dr. Deepak Tilak sir, Dr. Praniti Tilak madam, and Honorable Mahesh Lohgaonkar sir for their constant support in conducting such sessions. I'm grateful to respected principal and the head of the department, Dr. Murthy sir, and our respected principal, Dr. Prakash Deshmukh sir, our course coordinator, Assistant Professor Varsha Badwe madam, and Dr. Gauri Kala madam for arranging such a beautiful webinar. Heartfelt thanks to all the faculty members for the efforts in making this session successful. I would like to appreciate the today's host, Nagaraj Shetty, for the effort he has taken. And last but not least, all the dear students. Thank you all the students for attending and patiently listening throughout this webinar. Concluding today's webinar, once again, I thank you all. Thank you, sir.
Thank you very much.
Thank you so much, sir. Thank you so much.
Thank you. Thanks to all. Okay, bye.
Thanks a lot, Mane sir. Thanks a lot.
Thank you, sir.
Thank you very much, sir.
And with this, we declare that this session is
Thank you, sir.
Thank you, sir. Thank you, sir.